There's 2%. Those statutes.
'23 refers to an institution which is not established or incorporated by or under a central act, provincial act, or state act. The substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier
Yes.
which were using the expression university,
Yes.
though they were not covered. They were not.
So you are given 2 years.
You are given. It's a sunset clause.
Absolutely.
You're given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted under an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution.
Exactly.
Those laws all continued post-independence.
Yes.
So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees.
Yes.
That's how they acquire the right.
Right.
But your argument is without this, they wouldn't have had the opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But one of the point really is, and this is a different point, and this really tells your lordships the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906. It comes from 1906 because education is an occupation. You cannot, in an occupation, do what you like.
That regulation may also be traceable to 30. For instance, in the context of Article 301 of the Constitution, which is in part 13.
But that's on trade.
That's on trade. But our court said that regulatory measures which facilitate trade are permissible under 301.
But this point was dealt with in TMA-PI. The TMA-PI said, no, it is occupation. It's not charity. It's occupation. But the surplus that you make when you run an institution must be plowed back into the institution.
Actually, it may not arise here. But all that we are saying is that the power to make regulations, though expressly referable to 1906, is also implicit in 30, because 30, our court has said, 30, though absolute, cannot preclude the parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
That's
institution.
under 1906, Madad.
As an institution of excellence.
But Madad, that's under 1906. TMA-PI says that also. That regulation is under 1906. That's why, Madad, the absolute right is there, but the absolute right has to be regulated by standards.
Yes.
The absolute right is of the choice. Means I can set up a school, The school will be
That point
regulated
you
by the
made-
Education Act.
That point you made yesterday, that you can set up a primary school, a secondary school, a high school, an intermediate college,
Yes, whatever.
a degree college, or
That's
a
the
university.
choice. That's the choice. Now,
Because a university is also an educational institution within the meaning of Article
yes,
30.
yes. So therefore, but that choice can't be so absolute that you can do what you like. So you have to be you have to standardize your education in terms of the general standards set for all other educational institutions by the majority community or any other community.
And your argument really is this, which we'll hear the other side on, that if you apply the expression administer
Yeah.
in a very strict sense,
Yeah.
namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Manoj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education, it need not be only, but St. Stephen's had only 6% minority students at one point in time. Only 6%. Increased to 14% at some point in time. And then this court said in St. Stephen's, in TMAPI, it can go up to 50%. It need not have said so. That's why our Kerala education bill is sprinkling of minorities.
Also, one very important circumstance, you can't read Article 13.
Outsiders. That's correct. No, sprinkling of outsiders.
Outside.
Yeah, so therefore you could have outsiders, you will not destroy your minority status.
The object
That's
of
the
Article
point.
30, object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration. It doesn't detract from your character as
That's
a
the
minority.
point. That's the point I was trying to make yesterday. Now, Manoj, in this university, just to get the facts right, Manoj, there are several departments that are run. For example, All India Council for Technical Education. We have to go to them for recognition.
For medical college, you go to the...
For medical college, you go there. For the dental council, we go there. For pharmacy, we go there. For National Council for Teacher Education, we go there.
The law college will be governed by the Bar Council.
Correct, Bar Council. And there are different elements of administration in that. In the medical council, how will we administer at the university? We would not have any expertise. So we'll get outsiders to do it. Kindly see, Manoj, the impact of administration is again my choice. I hope, Manoj, I'm making myself clear. In some of these technical things, we'll have no knowledge, especially in a medical college. So we'll get people from outside and say, you please help us in doing this. And they may be in majority. But the choice is that I will say, please come. That doesn't destroy the character of my institution. So different standards will apply to different disciplines depending on the nature of the course that I am teaching. It is true of engineering as well.
The only difference here, we'll consider it. I mean, I'm not putting it as something against you, but a factor to be considered is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
That's all right. But I can challenge it. Well, let's put it this way.
Does that alter the...
No. I can challenge it, Malas. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malas, we are not here dealing with administration. This, Malas, please appreciate, Basha never dealt with administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute, and therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution because the administration is
use establish and administer disjunctively.
That
was the argument.
That was rejected in Basha. That was rejected in Basha.
There can't be any doubt that it's establish and
administer.
You can't read that and as or.
So therefore,
you have not. Dr. Dhawan has also not argued
and
that.
therefore, overwhelming participation of others in the administration, even if they are in a majority, even if by statute, will not destroy the character of the university. Because if I feel that my right is being impeded, I can challenge it. But I'm not. And the fact of the matter is, Mullahs, if your lordship looks at the structure, and you need not in this case, because we are not dealing with that. In fact, it was overwhelmingly Muslim despite the statute. De facto, But we don't have to go into that. We can't in a reference go beyond what your lordships are asked to decide. So, therefore, now therefore I was trying to show, that all these regulations fall under 19.6. The genesis and the conceptual constitutional genesis is you can't have institutions in the country without standardization in the field of education. And that standardization can only be provided by law under 19, and the law will apply to majority institutions and to minority institutions. And UGC and all other statutes are consistent with 19. The right under 30 is absolute, the choice, but the regulation is to be done under a law by Parliament under 19.6. That's the submission and the interplay of 19.6 with Article 31 of the Constitution. Now, which page is?
417.
The context of what my Lord has put in, my Lord the Chief Justice. Kindly note, I won't read it. Kindly note, volume 5A, PDF 417, paragraph 41 of St. Stephen's. Volume 5A, PDF 417, paragraph 41 of St. Stephen's. And I'll read that sentence to you. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. That doesn't limit it to the minority. This is 5A, PDF 417, paragraph 41. This sentence is between placetum G and placetum H.
Page number?
417, volume 5A. It's between G and H, which says exactly what I'm trying to, let's say, consistent with my submission before your lordships.
Actually, therefore, it's important to clear a cobweb, which is that Article 30 does not mandate that administration must be only by the minority itself.
That's correct.
In the sense that the personnel who administer are not required by Article 30 to belong to the minority itself.
Exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer.
That's correct.
In a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
Just to give an example, that I have myself experienced, I happened to be in the governing body of St. Stephen's at one point in time. Most of it were non-minority people.
The essential element of Article 30 is the conferment of choice on the minority.
That's correct. That's correct. So we are missing the link.
It can't be read in the reverse to impose an embargo that you will not have anybody save your community.
Well, the minority will not have the expertise to run the institution. Many of these institutions will not have. For force, we'll have to take people from outside. That's why St. Stephen says, have faith and founders in whom the founders have faith and confidence. I have confidence in 10 people in the majority community to run my institution. I'll give it to them to run it. Doesn't make the institution a non-minority institution because it is founded by the minority. The inspiration to set up an institution is that of the minority. The steps taken to set up the institution is of the minority. The persuasion done by the institution to the government and the authorities is by the minority. So as long as these elements are satisfied, It's founded by the minority.
Can you come again on that? The inspiration to set up.
The inspiration to set up the institution is by the minority. The steps taken for persuasion are by the minority. The essential paraphernalia of initial funding by the minority. Persuading the authorities to accept that fact by the minority. And all these elements are satisfied in this case. So the genesis of the institution is the test. That is antecedent to recognition. All that is antecedent to recognition. And Basha says, because you are incorporated, you have lost the status of a minority. This is the problem. This is the problem with Basha. And remember, Malats, when Basha was decided in 68, in-ray education bill was already there. Not referred to in Basha.
It is referred to.
Not dealt with. Siddhaj Bhai.
Dealt with also.
Siddhaj Bhai already there. And of course, now we have TMA Pi and other issues, other judgments. So the interplay of 1906 is fundamental. Now, Malats, Council for Architecture, we have people giving degrees in architecture. We don't have Muslim community people in architecture. Enough. Anyway, so I'm done with this part.
Now what remains, Dr. Mr. Sibal, what remains?
I've already said they glossed over, yes.
What remains now, Mr. Sibal?
Now, Malas, a couple, how the reference came is very important, Malas. I'll just give your lordships that. Now, Malas, as your lordship knows, give me that note. I'm just giving you that.
Mr. Sibal, you're quite proficient from where you began last year on your laptop.
No, I'm very proficient, Malas. Now I'm completely, it's just that it'll be quicker if she does it than I, Malas, do it.
Inspired by your example.
No, I do it.
But Dr. Dhawan, you have not made any progression at all on that. Just, I must also tell you that there's a world of literature which opens up when you use your iPad.
Absolutely.
Which is so,
Absolutely. Yeah. Not
forget
just,
forget all this.
There's also a world of abuse that opens up.
Of course.
We have to suffer, get enriched by one and suffer the other.
Myself from agreeing with Mr. Sibal.
Now, let's just see. Just note these days. 1899, the MAO College was formed. 1899. MAO College, Old Boys Association was formed. Who is the petitioner here, Maharaj? 1899.
Old Boys Association.
Old Boys Association was formed. And who's the petitioner? I mean, I'm the petitioner here. In 1920, the Aligarh AMU Act was passed. And in fact, that's just a matter of interest, the ordinary members of the court were to be appointed by the Old Boys Association from its own members. That was as per the statute.
The ordinary members of the court
were to be appointed by the Old Boys Association as per the statute. That was the extent to which the Old Boys Association was associated. Then your lordship knows, and I will not trouble your lordship because just Dr. Dhawan has dealt with it. The 51 Act came, which amended Mullahs.
Yes,
the Act was amended by the 51.
It means prior to 2020.
In the 2020 Act.
In fact, in the type version, it's been missed out.
It has been missed out in the type version, it is there. In the
what is the next
version.
date? Were you saying, Mr. Sibal, what is the next date? I missed that.
Yeah.
What is the next date?
Then 1965, it was further amended, Your Lordship.
The
No.
first amendment was in 1951.
Well, it's really the essential element was that Section 9, which earlier said instructions in Muslim religion would be compulsory to Muslim students, that was omitted. That's all that happened. So Basha,
In 1951.
yes, in 1951.
What happens? Just tell
Well,
us.
as the instructions in Muslim religion would be compulsory to Muslim students, that was omitted. So Basha says nothing much happened, no real amendment. It became optional. It became optional. So it had no impact on the decision in Basha. And then the proviso to 23 was also omitted, that only a Muslim can be a member of the court. That also was omitted. Just these two things happened. So therefore, but factually only Muslims continued, but there was a 23. That's what happened under the 51 Act. Now, in the 65 Act, which also has been dealt with, but I just tell your lordships in a second as to what happened. All powers of the court were given to the Executive Council.
Mr. Sibal, we have the reasons why the 51 amendment was moved, reasons or objects and purpose of that?
No, I've not investigated it. I'll find out.
Can you just tell us the 51 amendment page, or Junior can just tell you which is?
Yes, page 99 is the first, paragraph 2B, page 99.
Of volume?
Mullah, can I just upload it? This we've given a chart, it's better.
Sure, but 1951.
Volume 4A, I just give it,
4A.
volume 4A, at page 99, is the
1951.
Oh, your lordship wants the 51 Act or the 65 Act?
51.
51 Act, Mullah, the first amendment is the Section 9 amendment is volume 4A at 90, paragraph 2. At page 90, paragraph 2.
Yes.
Which omitted Section 9. The second amendment of proviso to Section 23 is 4A again, page 93, paragraph 17. 4A again, page 93, paragraph 17. So those are the two amendments in the 51 Act. The religious instruction was made optional for Muslims, and can I just airdrop it, Mullah? It's just a note. You just do it now so that it's easier. We've done it, Mullah.
51, it shows.
Because it's. Yeah. I know that. The screen.
What?
That's right. Normally, I just point out. So this was on the 51 Act. Then the 65 Act, Mullahs, what did it do? In volume 4A, page 99, para 2B, the powers of the court were given to the Executive Council. This is volume 4A,
This is also volume 4A. Mr.
4A. All is in 4A, page
Powers of-
99.
Powers of
Powers of the court, erstwhile powers of the court were given to the Executive Council.
Council.
That's at page 99 of volume 4A, paragraph 2, small b. And then statute 8, that is members of the court, was amended.
statute
8, which is members of the court, was amended. That's in 4A at 102. Page 102. And then the other was all existing members of the court and executive council were ceased to hold their office. That's at page 105, volume 4A again, paragraph 10. Right. This was an emergent situation, was. And this then in 65 was challenged, not by AMU, not by anybody else, challenged in a PIL petition, which resulted in Basha in 1968. The Old Boys Association were not parties, AMU was not party.
This challenge, I think, include 1951 amendment also.
Yes, yes.
Both.
But Basha said 51 really is not too relevant. 65, both were under challenge. What happened thereafter, and this is very interesting, brothers. During the court, when this came up in Parliament, and at that time, Mr. Chagla made a statement, which I give it to your lordships. That's in volume 4C. Yeah, 4C 1325. That's important for us.
4C page 1325.
25.
Mr. Chagla is the Minister of Education.
Yes, correct, Mullah. At 1325, volume 4C.
बंद कर दो मेरे को।
I didn't forget it.
Because Malaz Aliawar Jung was then the vice chancellor. Malaz, there was an agitation because the institutional, remember Malaz, there's a school there. There's also institutional reservation that was reduced from 75 to 50%. There was a huge agitation all over the country. And the Aliawar Jung was injured in the process and he was manhandled. So therefore, as a temporary measure, they sort of said, we must stop this maladministration. That was the reason for this. But kindly see, Malaz, at this, at volume 4C, page 1325. What Chagla says, Malaz, in Parliament. So that's it. My lords have.
Yes.
Now kindly see, Millards, Mr. Speaker, on the right-hand side. As we all know, we are facing a very serious crisis just now. There is aggression, there is undeclared war. We should do everything in our power to maintain communal peace and harmony. We should not say a word which will interfere with the harmony which exists and which should continue to exist. Today, we should think of ourselves not as Hindus or Muslims, but as Indians, one and all. I wish, Millards, this reverberates to reverberate it in India as we stand here. Now, I am a great deal in agreement with what Mr. Mukherjee said. I have said this before and I repeat it. I repeat it with all the emphasis I possess that this bill will not in any way affect what Sri Mukherjee chooses to call the special character of the university. The Academic Council has not been interfered with. This bill does not touch the academic studies in the university. The academic studies will go on as they are. I also reiterate what I said before, that this is a temporary measure. Kindly note that. An emergency measure